Hi, everybody. My name is Raquel Manzanares, and I am an attorney at the Student Legal Services Office. And the Student Legal Services Office is a student-funded office on campus. We provide advice and counsel and representation in a number of practice areas, including immigration, employment, housing, consumer protection. We handle code of conduct cases, can give advice about your meeting with conduct advisors. And today we're here to talk about the eviction moratorium and what it means for students. And with me, I have attorney Aaron Dulles from Community Legal Aid in Springfield.
Hi, I'm Aaron. I'm one of the housing attorneys at Community Legal Aid based out of our Springfield office. So landlord-tenant law is one of my specialties. I think between myself and Raquel, we've got quite a lot of landlord-tenant experience. So I think we're well prepared to handle this topic.
Yes, and we used to work together. We don't anymore, but we did. So I thought it would be nice to do this as a little bit of a dialogue, make it a little bit more interesting. If you have questions, type them in the chat box and we have a moderator who will ask us the questions. So we'll follow the format and, you know, she can interrupt us or ask at the end, either way. So the first thing, let me lay the foundation of what we're going to talk about here. First, we're going to talk about types of tenancies very quickly. So that you can identify what kind of tenancy you have. And that will allow you to then transition into our next topic, which will be how those different kinds of tenancies can be terminated. And then once they are terminated, well, so how they're terminated, and once they're terminated, what the next steps are and how the eviction moratorium has changed that or impacted that at this time period. And then we'll talk a little bit about some of the consequences that flow from not being able to pay your rent or from breaking your lease. So I'll start with the types of tenancies that are most pertinent to students are tenancies under a lease and tenancies at will. So those are different in a number of ways, but for purposes of this, it's important that you know that tenancies under a lease are for a term. So they have a start date, they have an end date, and you can only terminate them for cause. So because some provision in the lease has been breached, or for non-payment of rent, and that's pretty standard in the leases that we see in Amherst. The tenancy at will is a tenancy. It can be verbal, it can be written, and it does not contain a term. So it has a start date, but it doesn't have an end date. And those can be terminated for no cause, you know, just because the landlord wants to end it for any reason. And they can be terminated with a full rental period notice, or they can be terminated for cause, or they can be terminated for non-payment of rent. So does that sound accurate, Aaron?
That is perfectly accurate. I think the key distinction between being a tenant at will and being a tenant under a lease is just month to month. Are you month to month or not? If you are month to month, then the landlord doesn't necessarily have to have a reason to evict you. If you do have a year-long lease, then you have to have done something wrong to be evicted, whether it's non-payment of rent or other types of cause. And for the purpose of this discussion, it sounds weird to say cause and non-payment are different, but they are. Tenants' rights in eviction process are very different depending on whether the cause is for non-payment of rent or some other type of cause. But again, if there's a lease, there needs to be some grounds for the eviction. With month to month, the landlord can proceed with what they call a no cause or no fault eviction. Month to month can be written or it can be oral, but if there's a lease, it will always be something that's written, and it will say, you know, a 12-month period beginning at this time and ending at that time.
Thanks. So how is a tenancy terminated? So it's April 5th and I haven't paid my rent because I don't have the money, or I don't like my landlord, or for whatever reason I haven't paid my rent. And so how, Aaron, what would my landlord do in that situation?
Well, First, I just want to say when we're talking about terminating a tenancy, what we mean is ending the contract, a contract where you get an apartment or a house or whatever, you get possession of some property in exchange for rent. That doesn't necessarily mean the actual physical eviction. That's later on in the process, but the first step is to end that contract. And if you haven't paid your rent by the 5th, and I want to begin the eviction process, then I would send you a notice called a notice to quit, or a notice of termination of tenancy. And I would say in that notice, I would tell you when your tenancy is coming to an end and why, if there's a reason for it. If you have a lease and you haven't paid rent, I would say this is a non-payment notice. For a non-payment notice, you have to get a 14-day heads up before your tenancy is officially considered terminated or over. 14 days is the time period for non-payment.
Does that mean that you have to move out? If you get that thing saying that you have 14 days, you know, they want you to leave in 14 days, does that mean what happens if you don't leave in 14 days?
If you don't leave in 14 days, then your tenancy is over, but the landlord cannot himself or herself forcibly eject you. They can't call the police to forcibly remove you. The only way you could actually be removed is after going through judicial process in court, an actual eviction case, which is called summary process. And only if the landlord wins that case, or you enter into some agreement in that case, allowing the landlord to win, only at that point could an actual physical eviction happen. Even then, it can only happen at the hands of a constable or a sheriff. So under no circumstance can the landlord compel you to leave without going to court, winning the court case, and then getting the constable or sheriff to actually put that into effect.
And so I'm a landlord, and I've given this 14-day notice to quit. By the way, if anyone gets a notice to quit from their landlord, come to the Student Legal Services office, fill out an intake form, or fill it out online, send it in, because there are particular things to kind of plan for in the event that it gets further down the road. So, but all right, so I'm a landlord, and I've served a notice to quit. And it's been over 14 days and my tenants haven't left. What's my next step?
Well, I just want to make clear, the hypothetical we're talking about right now is before the eviction moratorium law. The eviction moratorium law changes a lot of this temporarily. But if I've sent you a 14-day notice to quit, you received it, 14 more days passed after you received it, you're still there, then I actually have to start the court case. And to do that, I have to file something called a summons and complaint. It's a standard form filed with the court. And I actually have to send you a copy of it first. And then after you receive that copy of it, then I go file the original paperwork with the court. There's timing deadlines around that. So I would serve you with the summons and complaints, and then I would have to file that with the court between 7 and 30 days after I serve you with the summons and complaints.
All right,
and then the court case begins.
So how did the eviction moratorium change that?
The eviction moratorium says that non-essential evictions, in short, non-essential evictions cannot go forward. So the first question is, well, there's a couple of immediate questions. One is, what's a non-essential eviction? And two is, what does it mean that it can't go forward? So a non-essential eviction is an eviction for non-payment of rent. That's not essential. An eviction because you did something else wrong, you broke your lease in some other way, that is also not an essential eviction unless what you did or are alleged to have done involves criminal activity that could impair the health or safety of other residents, healthcare workers, emergency personnel, or other people on the property. So even criminal activity that doesn't impact health or safety of others is not adequate. It has to be something that impacts the health and safety of other people. And the same is true of other kinds of just general lease violations. The lease violations that impact health or safety of other residents, healthcare workers, emergency personnel, other people who are lawfully on the property, the general public. If there's a health or safety reason for it, then it could be considered an essential eviction. But
can you give me an example of something that would be that would impair health or safety, sort of in your opinion? I know, you're not the arbiter, but.
Well, I'll give you the clearest example is an example that I actually am aware of from not terribly long ago, where a landlord wanted to evict a tenant because the tenant's son was arrested for murder. Now, if your tenant's son is on the property, lives with you, and has been charged with murder, then there are obviously allegations of health or safety, criminal activity involving health or safety. But there's a lot of gray area between that and, say, copyright infringement, which could be considered criminal, but certainly does not impact the health or safety of other residents. And this is why lawyers have jobs, because there's the huge gray area in what does or doesn't qualify as a health or safety issue. But I think one of the most important points, I would generally say that absolutely doesn't qualify as a health or safety issue. Now, there could be a circumstance where a tenant is causing fires in the property, or a tenant is falling asleep smoking cigarettes in bed, or something like that. That much more approximates a real health or safety issue.
I think what I'm trying to point out by asking these questions is that every situation can be argued in one way or another. And so you really do have to kind of seek the services of a lawyer if you don't know if the behavior, goes over the line or not. All right, so I'm sorry I got you kind of off track. So non-essential evictions is where you left off.
Right, and I just wanted to emphasize that, and because this is very important, I think, for a huge number of people right now, not paying rent, that's a non-essential eviction. If you're not paying rent, the eviction for non-payment of rent is non-essential, and so the eviction moratorium does freeze that process from moving forward.
So say that I'm a tenant. I lost my job. I can't pay my rent. I now know that if I've been listening, that the landlord can't physically remove me from the property or have me removed. Can the landlord start a proceeding in court so that as soon as the moratorium is lifted, we go to court immediately and I get evicted from the property?
No, the moratorium freezes the process at its very earliest stage, which is that notice to quit or notice of termination of tenancy. That's the document that landlord sends the tenant saying, I'm giving you 14-day heads up, 30-day heads up that your tenancy is ending, you should leave. If you don't leave, I'll have to go to court. Sending even that initial notice of termination, the notice to quit, that is prohibited right now by the eviction moratorium law. And in fact, the eviction moratorium law says that a landlord cannot send any notice, including a notice to quit, requesting or demanding that a tenant leave the premises. So the landlord can't send a notice to quit to actually legally end your tenancy. The landlord can't send other kinds of less formal demands or notices for the tenant to leave. So the case does not even get to the court stages. Your tenancy is not ended. You are still a tenant. The landlord cannot end your tenancy. And remember,
how long?
That's the prerequisite to going to court.
How long is the eviction moratorium in place?
The eviction moratorium is in place for, and Raquel, you have to remind me, did this pass on Monday?
Monday the 20th.
Monday the 20th,
Monday.
Okay. Let me see here. I believe it is, okay. 120 days after Monday the 20th is when this moratorium comes to an end, or 45 days after the statewide COVID-19 emergency declaration is lifted, whichever date is earlier. So if the governor lifts the COVID-19 emergency declaration today, then 45 days from today is when the eviction moratorium would disappear. If the governor doesn't lift the eviction moratorium for months and months and months, under the current law, the eviction moratorium is still going to disappear 120 days from when it passed.
But is there a provision for it to be extended?
Yes. The governor can postpone the end of the eviction moratorium and cause the moratorium to continue to stay in effect. The governor can do that in increments of 90 days. So any extension of the eviction moratorium ordered by the governor would be a 90-day extension. But in no circumstance can that extension go beyond 45 days after the emergency is over.
Okay. Okay, so I didn't pay my rent. I'm not going to be physically made to leave the property. That's great. What do I owe rent for the time that I'm living there and can't pay rent?
Yes, you owe rent. You still owe rent. Now, if you can't pay rent, often landlords will want to do things like, send you a 14-day notice. Obviously they can't do that under the new eviction moratorium law. Landlords will also often want to charge a late fee for the rent you haven't paid. Now, the background law here, the law that was already in effect before all this took place, says that the landlord cannot charge that late fee until your rent is at least 30 days overdue. That's still the law, but now there's an additional provision where the landlord also can't charge a late fee if within that 30-day window, the tenant sends the landlord a notice that says quote, notice and documentation that the non-payment of rent was due to financial impact from COVID-19. So if you lost your job and that's why you can't pay the rent, then within 30 days of that missed rent payment, and that's the 30-day period where the landlord has to wait that long anyway before he can charge a late fee. If within the 30 days from the missed rent payments, the tenant sends the landlord notice and documentation saying the non-payment of rent that's existing right now, that's because of this financial impact from COVID-19. If the tenant does that within the 30 days, the landlord cannot charge a late fee and also cannot report that to a credit agency.
So what does documentation mean? I lost my job. I send my landlord an email saying I lost my job because everybody got laid off. What can I possibly send them? I mean, if my supervisor just told me we're not going to continue to have you come into work.
That's good. That is very much a case-by-case situation. And so those are always the situations where if you're uncertain, you might want to talk to an attorney. But generally speaking, my general advice in a situation like that would be, well, the best documentation you happen to have. So if, for example, you're going to apply for unemployment insurance and you're approved for unemployment insurance based on losing a job, then the notice of approval from unemployment insurance would certainly appear to be more than adequate. Maybe you can get an email from your former employer saying your last day of work was on this date. That would be documentation. Essentially, you do what you can in that situation, do what's reasonably within your ability to do. If there is no type of documentation that you reasonably can get, then send the notice anyway is what I would say, because frankly, it is certain that you could get that documentation later on, and a landlord in that situation will hopefully want to err on the side of caution and not violate this law and not quibble with you over documentation.
What if I was paid under the table? So say my employer they're not going to give me anything because they don't want anyone to know that they were paying me under the table. What do I do?
That's an interesting question, Raquel. What would you do?
I think that I would send.
I would send a notice anyway.
It depends on the situation. I would send the notice anyway, and if my landlord rejected it, I would just hold on to the copy of what I had sent, and kind of wait to see what happened later. I mean, essentially, if it came down to it and you were in a dispute with the landlord, you would have to figure out a way to show that you had been working. And just the fact that you were making rental payments might be maybe not sufficient, but a good step in that direction.
Well, and one thing that's important to note here as well is the documentation. It says the tenant has to provide notice and documentation to the landlord that the non-payment of rent was due to financial impact. It doesn't say due to the loss of a job. It says due to financial impact. So suppose you are a student who is not working and is able to receive some kind of regular income from a family member who can no longer afford to do that. You might, for example, have bank account balances that show a fairly steady balance and suddenly it's dropping in the red. You might have credit card bills that are increasing. You might be falling behind on other utilities. Other kinds of documentation generally about financial impact would certainly suffice because the law doesn't require it to be documentation on the loss of a job. It just says documentation that it was due to a financial impact.
And so my parent losing their job or being laid off, that would count?
Absolutely. It does not have to be your own loss of a job. It just has to be a financial impact to you that is attributable to the COVID-19 crisis.
So would a financial impact to me be, never mind, strike that question. I'm not going to ask it.
But just to build on what you said about if you literally have nothing to send, it is important to send a notice anyway, even if there's no documentation you could put alongside that. If the landlord at that point decides to send you a notice of termination of tenancy anyway, well, you'll hold on to that. You'll hold on to what you sent the landlord earlier, but nothing's going to go forward at that point anyway, because the courts will not accept new cases at this point until this eviction moratorium is lifted. So even if the landlord decides that they are entitled to send you a notice, and the landlord is completely wrong about that, and the landlord decides to charge you a late fee despite the notice and documentation, well, they're not going to get particularly far with an actual eviction process. They can't send you the notice whether you're late on rent or not. They can't send you the notice to terminate your tenancy if you didn't send the notice and documentation about the financial impact. They just can't send you a notice of termination of tenancy at all. The notice and documentation of the financial impact is really about late fees and avoiding late fees, and it's about credit reporting issues and avoiding a negative credit report.
So what if the landlord, if I don't send that notice, is the landlord is able to report it to a credit agency, right? If I don't send it within that 30-day period?
Correct. You have to send it within that 30-day period.
So what if my landlord rejects the notice I've given, sends me an email and says, this isn't sufficient, where's the documentation? I can't give any documentation for some reason, even though submit an intake form will help you come up with some form of documentation that you can send. But then if they report it to a credit agency, like, what am I supposed to do about that? Because that doesn't require them to go to court, does it?
No, it doesn't require them to go to court. If you sent them a notice and documentation of the financial impact and they say, well, this is not documentation, or you didn't actually attach any documentation, so I'm going to report you to a credit agency, even though you sent me some notice, then at that point, you may have legal claims against the landlord for based in the same types of laws, for example, that apply to debt collection and false credit reporting. So that's a situation where you would definitely want to speak with an attorney about the particulars of your situation.
I have a question from a participant, if I can. Since you're talking about reporting to credit agencies and other potential consequences of not paying rent, there's a question with respect to whether or not a landlord can hold the fact that a tenant hasn't paid rent against them when determining future leases. The exact question is, if a tenant hasn't paid rent during the period of this moratorium, can the landlord hold that against them for future leases?
The answer, I believe the answer is yes.
So do I.
Right. The landlord can make decisions on who to accept as a future tenant, essentially for any reason under the sun, unless there's a specific law saying that reason doesn't count. For example, race, sex, gender identity, national origin. Those reasons are all off the table for making those kinds of decisions. But other reasons, like, you just were kind of crummy with your rent payments during the COVID crisis, the landlord can choose to do that legally, yes.
Yeah.
And
So
that's why communication is really key here. If you want to have another lease with the same landlord that you can't pay rent to right now, maintaining a healthy relationship with that person is fairly important.
And I don't know if you guys are going to cover this a little bit later on, but is there any provision in the new law for a tenant to terminate a lease early and vacate without penalty rather than continue to occupy and simply not pay rent?
no. The answer is no. So I know this is a situation that a lot of students are in, is a situation where you either can't pay rent but have another place to live, so you'd like to give up possession, or you can pay rent, it's a stretch but you can still do it, but you don't have a reason to be in Amherst, right? Those are two different situations, but ultimately there's nothing in the eviction moratorium that allows you to break your lease early. I would go back to the same advice that I've been giving in previous presentations and to individual clients, which is exactly what Erin just said about communicating with your landlord. I do think that, you know, there's the smallest of chances that if you can at least give your landlord the opportunity to try to re-rent the place, that you can maybe cut off some of the damages that you're going to accrue as you go forward in not vacating and not, so the landlord has a duty to mitigate. You know, if you leave early and break your lease and are clear in your intentions to do that and give up possession of the property, they're supposed to make reasonable efforts to find another tenant, so that you don't just have this ongoing rental obligation that goes till the end of the lease. If they can fill the space and get paid otherwise, they should. But we're in this time, there's not a lot of people moving. So the chances that your landlord will be able to successfully mitigate are lower than I think they've been at any other time in recent or non-recent history.
So in the event, what kind of advice would you provide to a student that vacated in early March, but the lease runs through August and the house has been empty? What would you advise the client to do, and what options are available to that person?
Well, the first thing is what Raquel just said, which is about the landlord's duty to mitigate. So if you have a lease that runs out at the end of August, you are still contractually obligated to pay rent for that entire period. Whether you do or not, you still are contractually obligated to do that. But the landlord is also obligated to accept another tenant and even look for another tenant. So if you happen to be lucky enough to be able to assist in that and help find another tenant to take your place, then you could cut off the loss to yourself early by finding the replacement tenant. Then that certainly would be helpful, but obviously that's going to be close to impossible for a little while.
But I do think that giving up possession, if you don't intend to live there or return, is important, because the landlord's not going to be able to fill the space if you're still holding onto the keys and still have your stuff there, obviously. But even more than that, if you give up possession, it means that you will stop being responsible for the house just sitting there, right? For something occurring, you know, the house becoming insecure for some reason, someone breaking into it, right? You want to return possession to the landlord so that you don't just have this house in Amherst that you really should be checking on and making sure everything is okay there, and you know that there's a pipe hasn't burst, right? You want to give that obligation back to the landlord. I think that would be important to do. Is that a satisfactory answer, Bernie?
I haven't gotten another question, so I believe it is.
I should make mention of one other thing, and that's about last month's rents and security deposits. So Raquel, if I can't pay my rents during this COVID crisis. And when I moved in, you know, I gave you first, last, and security. Can you just take that money? Can you use that money? Can you just take that instead? Can I say, hey, just keep my security deposit?
So, it's a two-part answer, because with respect to the last month's rent, the landlord is allowed to use the last month's rent early, but they have to notify the tenant that they're doing that. And so they have to, I would have to pull out the exact language, but they have to give notice to the tenant that they're using the last month's rent early. With respect to and the tenant is still entitled to the interest on the last month's rent at the end of the tenancy, as though it had been sitting in the bank for the full year. So, I mean, that often means they're entitled to like $1.30, but just so you know, they're still entitled to the interest.
And just as some background to this, last month's rents and security deposits are different things. A lot of folks reasonably get them confused. Last month's rent is rent money that you just paid for that 12th month of your one-year lease. For example, a security deposit is money you will get back after you move out, provided you haven't put a bunch of holes in the walls and done other things. They are different things. Generally, the landlord has to hold that money and can't spend that money, neither the last month's rent nor the security deposit, until the time actually comes. So if I'm a landlord, I take a last month's rent, that has to sit in the bank, untouched by me, accruing interest, which is your interest that you are entitled to receive. And I can't touch that money until that actual last month of the tenancy. That's the general rule.
Yeah, and so in this instance, the eviction moratorium allows the landlord with notice to use that last month's rent for expenses, including mortgage payments, utilities, repairs, required upkeep. But the security deposit is a different situation, because that money still belongs to you. The landlord's not allowed to use it as rent. Now, does that mean you can't talk to your landlord and say, will you please apply the security deposit to one of these months' rent? Your landlord is permitted to do that if you both mutually agree that that's what they're going to do. But you have to understand that some landlords won't want to do that, because that means that they're no longer holding your money that will be used to cover damages. And so there's a general disinclination, I think, to convert. And many of the leases in Amherst, in fact, say the security deposit is not rent. It cannot be converted into rent. And that's for just this reason, that then they're not holding on to that. It's like when you go to the bowling alley, right? And you take out shoes, you have to give them your car keys or whatever, so that you don't just walk away with their shoes. Or you have to pay a deposit, right? The deposit is meant to encourage you to return everything in good condition, and also to cover the expenses if in fact you don't do that. And so that can't just be converted by a landlord because they want to convert it into rent. But at the end of your tenancy, if you've moved out and they are able to keep it for unpaid rent that hasn't been validly withheld. So at a certain point, it does get turned into rent if you leave owing money.
I think the important point about leaving aside security deposits, if you paid rent in advance for the last month of the tenancy, the provision of the moratorium law that allows the landlord to access and use that money is not a provision that is about your rent ledger. That's a provision about protecting the landlord, who might, for example, need to make a mortgage payment. The landlord might say, I can't afford the mortgage payments this month on the building because my tenants haven't paid rent, and they have these last month's rent sitting in the bank account that I would really like to use to pay my mortgage. This law will allow the landlord to access that last month's rent for their own expense, such as the mortgage payment. But in that situation, the law also creates this fiction like the last month's rent is still in the bank. So when you do get to the last month of your tenancy, you've already prepaid for that last month. Even if the landlord used that money early, you've paid in advance for that last month. And in fact, the interest you're entitled to is going to be calculated based on the hypothetical that the landlord never took it out of the bank in the first place. So if a landlord is asking to convert your security deposit or last month's rent into rent for your rent ledger, then that is something that would have to be done by agreement. If the landlord wants to access your security deposit for their own personal expenses, that is something that would definitely need to be negotiated very carefully, and certainly with additional legal advice. If the landlord wants to access your last month's rent for their own personal expenses, then that's something that they can just do. But they do need to send you something in writing saying they're going to start using your last month's rent payment for something, again, such as their mortgage payments. And the notice actually has to say that the tenant's entitled to the same amount of interest on their last month's rent as if the landlord had never taken it out of the bank, and some details like that. But this law is not just a blanket permission for landlords to use that money from last month's rent for present rent. That's not what it says.
But you can't, but the landlord can agree to do that if the tenant agrees.
Yes, if you're going to negotiate any type of agreement like that, however, it is absolutely critical that that be put down in writing, preferably an actual sheet of real paper with signatures on it and a date on it that says very clearly what the agreement is and how it works. And again, that's a situation where you would definitely want to go to Student Legal Services and talk to an attorney about the agreement that you're contemplating.
You also, any agreement, whether it's, you've called your landlord and they've said, well, your lease goes till August, we're willing to have you not pay August, but we're going to keep your security deposit and keep your last month's rent. Even if that was a phone call, then it's really important that you immediately, basically, my advice would be that you turn right around from that phone call and you send an email to your landlord saying, dear landlord, I'm writing to follow up our conversation. You said this, I said this, we agreed that. Please let me know if that was not your understanding. And that way, even it's not the best evidence, but it's a good solid foundation of, if there's no dispute made to that email, it shows that they didn't disagree, I guess is the.
And I have often seen this situation where somebody will send exactly that email, which is really important. It says, per our telephone conversation on the afternoon of Tuesday the 14th, blah, 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 this is our agreement. It's always important to say at the end there something like, if there's any misunderstanding or this is inaccurate, please let me know. Often those emails will generate a response that just says, okay, thanks. And then that's really good. That's good. You want that. You want the confirmation of the things you just said. It puts the onus on them to make some kind of response. And oftentimes the lack of a response can have value, can reflect kind of implicit assent to whatever you just said.
Yeah. Is there anything I'm forgetting about this eviction moratorium that, those were the main points that I intended for us to hit. Did anybody else have any questions about not being able to pay your rent, possible consequences? I mean, I guess my question actually, Aaron, is, so we go these months and months and months, say my tenancy actually ends, so my lease is over, and I move out. What is my landlord going to do to try to get that money from me?
Well, there's certainly, if you didn't pay the last month, they're going to keep the last month's rent. If you owe more rent beyond that and you've paid a security deposit, they're going to keep your security deposit money. If that still leaves you in the red on your rent ledger and you still owe money, then the landlord would have a claim against you. Essentially, it's a claim for breach of a contract. It's, you promised in a contract to pay me this money, you didn't pay me the money. they actually have to collect that money from you. They have to essentially sue you over it. Frankly, for a lot of landlords, depending on the amount owed and what the situation is in particular, that may or may not be worth it. Some people will want to go after that money and try to sue over a minor debt, maybe a small claims case. Other people might simply forget about it and walk away because it's not worth their time. That's going to be a very case-by-case decision by the landlord about whether to go after you for a debt, but it is a legitimate debt at that point.
And so say that
credit issues can still come into play.
But if the eviction moratorium is over, can they report it to a credit agency if I gave the appropriate notice? Like after the eviction moratorium ends, are they able to then be like, well, the eviction moratorium is over. I know you couldn't pay your rent because of some impact of COVID-19, but now you have to pay it or else I'm going to report it to a credit agency.
I believe so. As I read the law, once this law expires, the governor hasn't extended it for the 90-day periods, then we go back to the world of pre-existing law. And
so that doesn't make sense to me. I actually don't read it like that. So a landlord shall not impose.
I understand why you don't, Sue. Okay.
Do you understand why I don't, but you think I'm wrong?
No, it's just a curious question.
Yeah, it's not entirely clear if that, because it doesn't make logical sense that, I mean, it doesn't make, the intent couldn't have been or shouldn't have been that you owe rent for, say, a period of 3 months that was a direct result of the impact of COVID-19, and then, and you give the appropriate notice, and as soon as the moratorium is lifted, they can report that debt, without ever having to go through judicial process.
Right, but it does say that Section 3 of the law, which contains the prohibition on credit reporting, Section 3 and another section shall expire at the deadlines we talked about. And one of the provisions in the section that is identified as the section that will expire is the one that says a landlord shall not furnish rental payment data to a consumer reporting agency if the tenant provides a notice and documentation of why the payment not being paid due to a financial hardship. So this is going to be something that is ultimately going to have to get figured out in liquidation. I agree it doesn't make sense. If you have a financial hardship right now because of COVID-19, and now your credit could be negatively impacted and this law helps you protect your credit, it would seem sensible that the maybe blip in your ability to pay rent, hopefully just a little blip, is something that isn't going to affect your credit history at any point, not in the present and not in the future. The way the law is written, there is a very clear argument for this not being something that protects you indefinitely against negative credit report, but just temporarily protects you against it. So I suspect if this were to go in front of a judge, the judge would probably come down on your side, Raquel. I'm not quite taking a position, but on the position that you articulated, that the credit reporting obligation kind of lives on somewhat more indefinitely. That makes more sense, but this is a debatable point.
Yeah, it is. The other thing I wanted to point out is that, well, maybe I didn't have anything else to point out. I was thinking something as you were talking, and I guess I forgot what I was thinking. So any other questions?
There's just one question generally, and I know there's different rules with respect to student housing, but does any of this apply or to on-campus housing, or is there any assistance available for on-campus housing issues?
This does not apply to on-campus housing. So students who live in on-campus housing other than North Village. So put North Village aside, but students who live in on-campus housing, undergraduate students, are not tenants, they are licensees. They reside there pursuant to a license, not a lease, and they're not protected by the same landlord-tenant laws that tenants are protected by. So this does not apply to licensees. Do you agree with that, Erin?
How does it apply to North Village, if at all?
North Village, the students who live at North Village are tenants. So it applies to North Village.
I want to thank both Attorney Dulles and Attorney Manzanares for your time, for your preparation, and for your commitment to the students of UMass. Once again, if anyone has any additional questions, feel free to go online and submit an intake with our office. If we can't provide advice or if we can't help you, we can always refer you to someone who can. Thank you so much, everyone.